When you die without a plan, this is what happens. Your family, forced to sell the home you spent 30 years paying off just to cover court fees. It's called probate, and it swallows 3 to 7% of everything you built. Today, I'll show you the 3 simple moves that make it impossible. And here's what surprises people most. None of this requires wealth. One of these steps takes 10 minutes and costs nothing. Another costs less than a single month of probate fees. Most people learn this too late. You won't. First, you need to understand what you're actually up against. Probate is the legal process of settling your estate through the courts. If your assets are in your personal name when you die, they go through it. No exceptions for good people. No exceptions for loving families. Here's what that means for your children. Everything becomes public record. Anyone can look up what you owned. Your family waits. The average probate takes 9 months to 2 years. During that time, your house can sit frozen. Bills still due. Your children may be forced to sell the family home just to pay court costs. And the legal fees? They come off the top, before your family sees a penny. Now here's the part nobody tells you. The wealthy almost never go through probate. Not because they have better lawyers fighting in court. Because their lawyers made sure they never enter the courtroom at all. They use 3 legal tools, all completely accessible to you. None of them require wealth. They require knowledge and action. Quick note before we begin. I'm not your attorney. Laws vary by state. Use this video as your map, then verify with an estate professional. Now, move number 1. Remove your home from your personal name. Place it into a revocable living trust. I know how that sounds. Trusts feel like something for dynasties and yachts. They're not. A revocable living trust is simply a legal container. You create it. You control it. You can change it anytime you like. While you're alive, nothing about your life changes. You live in your home. You can sell it, refinance it, all normal. The word revocable means exactly that. You can undo it whenever you wish. But the moment you pass away, something remarkable happens. The home never enters probate because legally you didn't own it. The trust owned it, and the trust doesn't die. Ownership transfers to your named beneficiaries, privately, often within weeks, not years. No court, no public record, no forced sale. Your successor trustee, someone you chose, simply follows your written instructions. Now, 3 things you must know. 1, a trust that owns nothing protects nothing. You must actually retitle the deed into the trust's name. This is called funding. Thousands of people pay for a trust, never fund it, and die with a worthless folder. 2, check with your lender first if you have a mortgage. Federal law generally protects transfers into your own living trust, but confirm it. 3, a revocable trust does not hide assets from creditors or reduce estate taxes. Its job is speed, privacy, and control. And it does that job brilliantly. Cost? Typically $1,000 to $3,000 with an attorney. Compare that to probate fees on a $400,000 home. That could be $12,000 to $28,000. Gone. The trust pays for itself the day you sign it. Move number 2, and this is where most people slip. Your house is only one piece of your estate. Bank accounts, investment accounts, vehicles, even that dusty savings bond. If any of them are left in your personal name alone, straight to probate. So the second move has 2 parts, a net and a fast lane. Part 1, the pour-over will. A pour-over will is a safety net that works alongside your trust. It says one simple thing. Anything I forgot, pour it into my trust. The account you opened years ago, the car you bought last spring, anything that slipped through the cracks gets caught and directed home. But, and listen carefully, the safety net has a cost. Assets caught by a pour-over will still pass through probate first. It's a backstop, not a bypass. The forgotten asset takes the slow road, which brings us to part 2, beneficiary designations. Banks and brokerages offer something most people have never heard of. Payable on death for bank accounts. Transfer on death for investment accounts. One form, usually free, takes 10 minutes at your bank. It names who receives the account the moment you pass. No court involved. Many states even offer transfer on death registration for vehicles. So here is your system, working in layers. Layer 1, your major assets retitled into the trust. Layer 2, your accounts tagged with beneficiary designations. Layer 3, the pour-over will, catching anything you missed. One warning that could save your family a fortune. Your beneficiary forms override your will every single time. If your ex-spouse is still listed on an old account, They inherit it. Doesn't matter what your will says. Doesn't matter what the trust says. So tonight, do an audit. Every account, every listed beneficiary. Update anything that's out of date. It costs you nothing. And it may be the highest value 10 minutes of your entire year. Now, move number 3, the one almost everyone gets backwards. Set up a life insurance policy and name the trust as beneficiary, not your kids, not directly anyway. Here's why. Life insurance payouts are generally free of income tax to your beneficiaries. That part works no matter who you name. The problem isn't the tax. The problem is control. Name a minor child directly, and they cannot legally receive the money. A court steps in, appoints a guardian to manage it. More courts, more fees. Then at 18, your child receives every remaining penny at once. Ask yourself honestly, what did you know about money at 18? Now route that same payout through your trust instead. The trust receives the money. Your instructions take over immediately. Pay off the mortgage so the family home is free and clear. Clear any debts so nothing follows your children. Then distribute on your schedule. A third at 25, a third at 30. College paid directly, a home down payment matched. Your rules, your wisdom. This is how families pass on money without passing on chaos. 2 footnotes for accuracy, because details matter here. If your total estate is very large, into the millions, owning your own policy can pull the payout into your taxable estate. At that level, ask your advisor about an irrevocable life insurance trust. And second, retirement accounts like 401ks and IRAs play by different rules. Naming a trust on those can trigger faster taxable withdrawals for your heirs. Get professional advice before changing retirement beneficiaries. Full stop. So let's put the whole picture together. Move 1, your home out of your name into a revocable living trust. Move 2, beneficiary designations on every account backed by a pour-over will. Move 3, life insurance flowing into the trust, paying debts, protecting children. 3 moves, roughly $1,000 to $3,000, a few weeks of effort. Against that, probate, years of delay, public records, 5-figure fees, legal battles that have torn apart more families than poverty ever did. Here's the uncomfortable truth about estate planning. Every single person who dies without a plan had time to make one. They simply believed they had more of it. You are not planning for your death. You are planning for their life. The Tuesday morning after your funeral, when your daughter faces a courthouse or walks past it, keys already in hand, that difference is decided now, by you, while you're still here. If this opened your eyes, the full written breakdown is linked below. Subscribe if you want your money working for your family, not the courts. Because wealth isn't what you make, it's what you manage to hand over. I'll see you in the next one.